Drafting a complaint under the UDRP, the Uniform Domain Name Dispute Resolution Policy, may seem like a simple process, but it's not. And failing to understand the substantive requirements of the UDRP's three-part test, along with the required burden of proof that must be met by appropriate evidence and relevant legal arguments, could easily cost a trademark owner both time and money. In fact, two recent UDRP decisions make this important lesson incredibly clear. The cases, which were decided only about 2 weeks apart, are very similar, even though they were filed at different UDRP service providers by different trademark owners, and in only one case was a complainant represented by an attorney. So in one of the cases involving the domain name usaquickprint.com at the forum, the panel referred to poorly prepared submissions that were so sparse as to be largely unintelligible. And in the other case, involving the domain name perfume-oils.com at WIPO, the panel said that the complainant failed to offer arguments or evidence to support any of its contentions. Now, in both cases, the panels denied the complaints, allowing the current registrants of the domain names to keep them. These decisions should be a wake-up call for anyone who thinks filing a UDRP complaint is simply a matter of filling in blanks and submitting a form. While it's true that maybe 95% of all UDRP decisions have resulted in orders transferring the disputed domain names to the parties that filed the complaints, that does not mean the process is easy or should be taken for granted. Now, in both of the cases I mentioned, the complainants failed on the most basic requirement for any UDRP complaint, establishing that they had relevant trademark rights. Although both complainants cited trademark registrations in the United States, those registrations contained disclaimers that were fatal to satisfying even the very first part of the UDRP's first element, paragraph 4A1, which requires a filing party to prove that it has rights in a trademark or service mark. In the usaquickprint.com case, the decision refers to a registration for a logo or design mark that includes the text USA Quickprint, but the decision correctly notes that the registration includes a disclaimer that says, no claim is made to the exclusive right to use USA Quickprint apart from the mark as shown. Now, similarly, in the perfume-oils.com case, the decision refers to a registration for a logo or design mark that includes the text PO Perfume Oils, but it contains a disclaimer that no claim is made to the exclusive right to use perfumes and oils apart from the mark as shown. On this issue of the disclaimers, both decisions cite section 1.2.3 of WIPO Overview 3.0, which says that if the similar elements of the domain name are made up exclusively of disclaimed terms, trademark rights under the policy may not be found unless the complainant can show sufficient secondary meaning in the disclaimed terms. In other words, the disclaimers in both cases were so broad that the trademark owners actually had no relevant rights for purposes of the UDRP. And in both cases, the complainants failed to do anything to establish secondary meaning. And because every UDRP case requires a trademark owner to prevail on all three elements of the policy, the decisions could have ended right there by simply denying the requested transfers. But what makes these two cases especially interesting is that the panels made clear just how awful the complaints really were, not just that they failed on a single requirement. The shortcomings were especially egregious in the perfume-oils.com case, where the trademark owner was represented by an attorney. And the decision clearly faults the attorney for simply reciting the text of the UDRP without providing any supporting arguments or evidence. Now, I haven't seen the complaint, but the decision makes it sound as though the filing was nothing more than bare bones, even though WIPO's supplemental rules allow for the factual and legal arguments section of a UDRP complaint to contain up to 5,000 words. As a result, in addition to denying a transfer of the domain name, the decision concludes with a finding of reverse domain name hijacking, or RDNH, stating that complainant is represented by counsel who knew or should have known it could not succeed as to any of the required three elements of the policy. And it criticizes the complainant's attorney for making, among other things, no effort to support its allegations of bad faith, as required by paragraph 4A3 of the UDRP. And although the trademark owner in the other case I mentioned for usaquickprint.com was not represented by an attorney, the panel was no more forgiving of either party, actually. In part, here's what the decision says. Both the complaint and response in this matter are very sparse, with very little in the way of facts or legal argument, the bulk of which have been recited in the parties' contentions section. They leave many open questions, and the panel is left to try and intuit the overall situation and each party's position. From these poorly prepared submissions and very limited facts, the panel is unable to determine whether a respondent has any rights or legitimate interests in the disputed domain name and whether it was registered and used in bad faith. As a result, the respondent or domain name registrant prevailed, clearly not because of the strength of its arguments, but because of the complainant's failures, and every UDRP case requires a complainant to establish its case by a preponderance of the evidence. Now, together, these two cases provide an important warning to both trademark owners and domain name registrants in UDRP cases. Do not take the domain name dispute process for granted. As I often tell my clients, a UDRP complaint is similar to a motion for summary judgment under U.S. law, meaning that it should contain all of the relevant factual and legal arguments, supported by evidence and citation to appropriate authority, such as previous UDRP decisions and the WIPO overview. Failing to do so is a losing proposition. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.